The U.S. Department of Justice has officially cleared the final regulatory hurdle required to launch a federal gun rights restoration program. This marks the first time since the early 1990s that the federal government has moved to provide a functional pathway for individuals to seek the restoration of their firearm rights. The legal mechanism driving this shift is found in the federal code under 18 U.S.C. Section 925C. Qualified individuals can now begin the concrete work of petitioning the Department of Justice to reclaim their Second Amendment rights. To understand why this development is significant, we have to look back to 1992, when Congress explicitly stripped the ATF of the funding required to process these individual applications. Without that budget, the restoration process stalled completely, leaving citizens with past convictions, regardless of their current standing, with no way to clear their federal records. For over 3 decades, people who had successfully rehabilitated remained legally defined by their past mistakes because there was no mechanism to review who they had become. Section 925C remained a valid part of federal law, but for 34 years, the American people were functionally barred from using it. The Department of Justice has spent the last several months systematically resurrecting that 925C authority. This required assembling a new administrative framework, assigning the Office of the Pardon Attorney, and designing a specific fingerprint card, the FD1222. The DOJ then expanded this foundation by announcing an online application portal and building a dedicated federal firearms rights restoration electronic records database. This shift from theoretical policy to a high-capacity administrative system signals that the government is preparing for a massive influx of individual applications. Before going live, the final rule had to pass through the White House and the Office of Information and Regulatory Affairs, or OIRA. OIRA acts as the executive branch's final editor, serving as the ultimate filter for significant federal regulations before they reach the publication stage. The DOJ submitted the draft rule in April 2026, triggering months of internal review to ensure the program met every regulatory requirement. On July 29, 2026, OIRA finished its review and stamped the restoration rule with 3 critical words: consistent with change. This clearance confirms that the rule survived the government's toughest checkpoint and has been authorized to move into the final stages of implementation. The Department of Justice will now publish the rule in the Federal Register, which will serve as the official trigger for the launch of the online application site. The process is designed to let individuals present court records and evidence of rehabilitation to prove they can safely exercise their constitutional rights. This is the moment where years of anticipation for millions of people finally becomes a concrete, accessible government process. Because the official launch is imminent, organizing your personal and legal records now is the only way to ensure your application is ready when the portal opens. You can begin this preparation with the 925C Made Simple Workbook, available at legalgangsta.com/shop-1. This workbook simplifies the legal requirements, providing a framework for organizing court records, charging documents, and the credible references you will need to support your application. Additionally, you should visit fedgunrights.com to use the Federal Gun Rights Restoration Eligibility Checker. For a small fee, this tool generates a personalized report to help you determine if your history fits the specific restoration pathway outlined by the DOJ. After a wait that has spanned decades, the system is finally moving. The time to prepare your records is right now.